talk about the workers' rights during the COVID. Jack, you can start.
So, yes, good morning, everyone. And good morning to all. So this morning we had already here Mr. Ansel in Health in Action, which she had already explained to us regarding the rights of COVID-19. So today I'm going to explain what is your right regarding this COVID-19 once you get positive and you were been terminated by your employer. So I'm Jex Hernandez. I'm Vice Chairperson of PLU as well as the FADWU Secretary. So to know about Hong Kong Federation of Asian Domestic Workers Union, this is comprises of unions of local and migrant domestic workers with different nationalities, which includes the Thai, Chinese, Filipinos, Nepalese, and also the Indonesian. So working on holiday, this must be comply with the employment ordinance, which we had already mostly using it and used to do it. So during holidays, there are 3 types of holidays. One is your rest day, which is once a week. We had statutory holidays, which is 13 days in 2022, which is included the Buddha's Day, Buddha's birthday. That is May 8th this year. And next is the paid annual leave, which is 7 to 14 days. A worker is entitled to all rest days under the law, which means 24 hours rest day in a period of 7 days. So 1 rest day every week. So can the employer ask you to work on Sundays and public holidays and pay you with a compensation of cash for extra day of work? In here, the employer cannot pay you, but you have to arrange for a substituted rest day within 30 days. During statutory holidays, there are 13 statutory holidays should be granted each year, which is payment in lieu is not allowed. From 2022, the birthday of the Buddha is added as a new statutory holiday. That is May 8th, this year. If a worker is required to work on a statutory holiday, her employer must arrange for an alternative holiday in the period within 60 days before or after that holiday. So you can see in the screen the days of holidays, which includes the Lunar New Year, until the Chinese Winter Solstice, until December 22 or December 25. So mostly this is, it depends upon your employer, which one do you want to have. For the paid annual leave, a worker is entitled to 7 days of annual leave with pay after completing 12 months of service, another 7 days for the 2nd year of service, and 8 for the 3rd year. So every year it was added 1 day in your annual leave. So you can see on this screen, from 1 to 9 years, there's always an additional of 1 day in your statutory holidays, including in the 9 years or 10 above, that is already 14 holidays. So there's no additional here. The maximum is 28 days. So what is your right you have when you fall ill in Hong Kong? So according to the standard employment contract or to the employment ordinance, it was stated there that in your first year, you had 2 days sick leave each month, 24 paid sick leave in total, which is, this is the 2 years, 1 year of your sick leave. For the 2nd year, you have 4 days each month, which is equivalent to 48 paid sick leave every year. The maximum sick leave that you have in your own contract is 120 days. For your sickness allowance, a worker is entitled to paid sickness allowance, which is 80% average of her daily wage, or 4/5, which has been sick for 4 days or more consecutive days. Second, she has a medical certificate from the doctor. She has also accumulated enough for the unused paid sick leave before commencement of the sick days taken. So if you have that sick leave that you have not taken for the past few months, you can use it in the other months, but this still been paid to your sick leave. Next page, please. So during COVID, the employer should accept self-test RAT positive results from employees as proof of their sick leave application and the entitlement to sickness allowance. So during your time for having positive in COVID, you had your entitlement for your sickness allowance. If a sick migrant domestic worker has not accumulated sufficient paid sickness days to cover the period of sick leave, the government appeals to the employer to be compassionate and consider granting the migrant domestic workers paid sick leave. So a worker was sent, if you can see, there's a worker's case wherein a worker was sent to live on a car once she tested positive. She was only given to a field and her other needs were neglected. So under employers should provide to their migrant domestic workers free and suitable accommodation as well as free medical treatment. This is under in your standard contract. If the worker is subjected to ill treatment by the employer, she can terminate her employment contract without notice or payment in lieu of notice. So under the employment ordinance. So if you can see, there's the standard employment contract, which is stated there, your rights that will be given for your free and suitable accommodation, as well as your employment ordinance, that she will not terminate you during your ill treatment. Next is the termination entitlements. This usually includes your outstanding wage, unpaid wages, the return flight tickets. Employers can choose in cash, but the ticket for you, and buy the ticket for you. But regarding these flight tickets, it was already been mentioned that it was not been in a minimum of 1,000 Hong Kong dollar. For the food and traveling allowance, it's 100 Hong Kong dollar a day. The payment in lieu of notice, payment for untaken annual leave, the long service payment or severance fee, any other sum due to the workers regarding the contract. So what should you do if you suffer from ill treatment? Number one is to seek advice from the union, Federation of Asian Domestic Workers Union, or your own union. So if you are Filipino, you can go to PLU. If you are Indonesian, you can go to the United Union of Domestic Workers. If you are Thai, going to the FADWU, Thai Migrant Workers Union. And if you are local, go to the General Domestic Workers Union. And if you are Nepal, go to the United Nepal's Union. If you need shelter, FADWU can refer you to help for domestic workers shelter. Especially if this is an emergency, we will refer you to the help, which is partners of the FADWU. Or file a complaint in the Labor Department or Equal Opportunity Commission. Keep all the records related to your job. Never sign anything before consulting the union. This is a question. It is illegal for an employer to terminate an employment contract with an migrant domestic workers who has contracted COVID-19. So according to the Labor Department, violator is liable to prosecution and a maximum fine of 100,000 Hong Kong dollar. So in this time of COVID, there's a lot of domestic workers has been terminated by the employers during their treatment. So we had the Disability Discrimination Ordinance, which means disability covers a very wide range of illnesses and disease, all kinds of physical and mental abnormalities or disorders. So example of this is the coronavirus that we had already been tackling right now, wherein a lot of domestic workers has been infected and out of their employer's home. But then, this includes also the cancer, the influenza, cold, diabetes, gastroenteritis, depression, stroke, and the physical injuries, HIV, AIDS, and visual impairment. Firing a worker who contracted COVID is in violation of the Disability Discrimination Ordinance. So what is a disability? Under the Direct Disability Discrimination Ordinance, it covers a disability that is in the past, present, or future. So firing a worker who had COVID before and but recovered includes imputed to a person. To impute a disability to a person is to think that person is a particular disability, but in fact, that person does not have the disability. Firing a worker presuming she has COVID without proof. So just an example with the impunity treatment or the impunity disability. There is one example of the domestic workers who has been in a hospital for 2 weeks and terminated by employer. But then she was being the employer withdraw. Sorry. The employer withdraws her termination letter with her domestic worker after knowing that she will be having a penalty of 100,000. So when the domestic worker go out last March 1, when she go back with her employer, the employer gave her the termination letter as well. So that is a kind of a present and a future disability wherein an employer cannot still terminate her domestic worker because it's still considered a discrimination. She still violated the discrimination ordinance. So next. So what can a migrant domestic workers do if they are fired for test positive? Number 1, to get help and advice as soon as possible. 2, to write down what happened while memory is fresh and keep copies of supporting documents like contract, medical certificates, and etc. In here, there are employers who are getting your medical certificates. So make sure that you had your original copy of your medical certificates or at least a copy of your medical certificates. This is a proof that you had gone for treatment. So like the domestic workers who has been filing a case with her employer or a complaint with her employer, she cannot file because the medical certificate was given to her employer without her copy. So next, after you have this kind of, and can we turn it back? So after having this proof, you can file a complaint with the Equal Opportunities Commission at least 12 months or within 12 months. So, and then you can take the case to court within 24 months. So make sure that this is only the provision period where you can file a case in the EOC as well as to the court. After that, you have to report the matter to the police if there are criminal elements. So examples of losses that can be claimed under the Disability Discrimination Ordinance. Under the financial losses, you have your outstanding salary, your future salary, medical, treatment and therapy, and housing. For non-financial losses, you have the emotional pain and suffering, inconvenience, mental anguish, and the loss of enjoyment of life. So how to make an inquiry with the Equal Opportunity Commission? or EOC. So you can see in the screen their telephone number, you have the address, or you write them through letter or online inquiry form, or you can send it through fax or SMS for people with hearing impairment. Next page. And next page. So what are the information that you needed for filing a complaint? So who did, what to whom, and when? So who is the perpetrator? It is very significant that you have to know who is the perpetrator on your complaint. Next, we have to, what did the perpetrator do to you? What was the discriminatory act that you have done? So it should be clear what are the discrimination things that you have done to you before you file a complaint, and it's be clear that those discrimination acts had an evidence provided. Whom? So with whom, this is the aggrieved person who suffered from discrimination or the victims. And then when did this discriminatory act take place? So in here, we always said that it's very significant for us to write what are the things or what are the abuses that was being done inside your employer's house or outside your place or environment. So for the summary of this, for knowing your rights, just to know that employer cannot fire you for having a COVID. And then employer has to provide free accommodation and free medical treatment. Employer can buy your holidays and find FADWU for help or your own union for your help. So I think this is it. Thank you.
Okay, now we are opening for QA sections. So everybody, you can either mute yourself to speak your questions, or you can type into the chat box.
Hi, good afternoon, everyone. This is Sheila.
Hello there.
Yeah, hello, sure.
Yeah, I just want to ask. I just want to make clear. We said that there is no such thing as contract termination if you are found positive, because we know that there's already the regulations that employers cannot terminate a worker. But on the DDO, it's also clear everything. But then my question is, what about I feel sick and then I was cleared, or I got COVID and then I was cleared for about 2 months. And then my employer has to terminate me. But the reason is negligence. Is this can be connected with the past that I become a COVID? Because some employers are also trying to find ways that they can escape on this kind of situation, like they know the laws that they can be punished. So they will take some time before they were going to terminate you. So can a worker connect this as part of the termination? Thank you.
I just want to explain that under the discrimination ordinance, there is 24 months or 12 months to file a case regarding on your disability discrimination, providing such evidences and especially medical certificates that you had been positive on that on COVID-19. But then I still want to reassure on this matter because it's really very complicated. But if you look on the period of time of filing a complaint to the BDO, it was stated there that there is 12 months to file a discrimination, disability discrimination complaint. So with your question, Chair,
Yeah,
I will
that is the filing, but that is the filing. What I'm asking is, can we connect the termination of contract when I was positive in COVID, but because the employer knows that they can be penalized, they will terminate me immediately. So what I'm asking, after 2 months, she terminated me. Can I connect that? The reason of termination is not real if she said I have some negligence on my duties. But what I feel is she terminated me because I was become positive before last 2 months. Can I use that argument to file a case? I know the filing of case, the length of filing a case, but what I'm asking is the connection of termination, the reason of termination.
Jack, you want me to help?
yes, please.
Okay, so if you can remember, the Disability Discrimination Ordinance define disability in the past, present, or future. So if the employer is discriminating a disability in the past, it can be a violation. But of course, if the complaint is filed at the EOC and later at the court will consider all the circumstances, like what happened in the past, what is being talked about, what the employer said to you, what is the constraint and condition the workers is facing. So the judge or the court will consider all the circumstances. We have definitely already cases at the court file that the worker win the case, is that when the worker got ill and the employer didn't fire her or him during her sick leave, but once he or she resumed the work, resumed the job, the employer immediately fire the worker. And that is definitely a violation of the employment ordinance and also the DDO. But in the case of what you have mentioned, there is a time gap. Of course, the further the time gap after the worker is recovered, there may be more consideration to the disability. So in short, the court will consider the whole scenario, the circumstances, what happened before, during, and after, and also what are the conversation in between. Yeah, so it is a civil case, so it will depend really how and what happened. So as long as the worker feel it is a discrimination, and of course she has to really record and jot down what happened in all the time, and and for disability or for discrimination, we do have cases when worker file a discrimination violation and complaint to the court, like 3 years after the worker gave birth to a child. So we do have cases like that and complaint filed at the court like that. So as long as the worker feel that she really feel there is a discrimination, she record it, and we can always try to make a complaint. But what will be the outcome from the judgment of the court? The court will consider the circumstances. Yeah, so I hope I've answered your queries. So just try. Make a call to FADWU and PLU and your union and we will do an assessment, and then we can take recording on the situation, and we can try to make an assessment of the case on how successful it can be or not if we file a complaint under the discrimination ordinances. So for your information, we have 4 discrimination ordinances in Hong Kong. Besides the disability discrimination ordinance that we are talking about, we also have sex discrimination ordinance, race discrimination ordinance, family responsibility discrimination ordinance. So there are also cases that the discrimination can be 2 types and violation of 2 types of discrimination and the 2 ordinances together. So like domestic workers, usually they are women. So it may be also a discrimination not only on disability, but also the others as well.
We can answer the questions in the chat box. There's a question from Mary. What if the worker handed 1 month notice breaking contract for a couple of weeks? Then after the worker had handed the 1 month notice, in few days she got positive RAT test. Is the employer still obligated for her in this situation?
If the worker, because she had given one month notice, she said, if the worker is still working with, is still taking that 1 month notice with her employer's home, then the employer still have the responsibility once the domestic worker got positive. Because as she said here she had 1 month notice, so that means she's still living with her employer to finish that 1 month notice that she have. So once, as long as the domestic worker is still staying with the employer, so that means that the employer has still the responsibility for her domestic worker if she gets sick or get injured, because she haven't finished the 1 month notice that she have and still working with her employer. I hope I answered the question.
I have further question on that. Should the employer give her the sick leave and the sick leave doesn't count into the 1 month?
Can you repeat, Anne?
Like if she tests positive within the 1 month notice, so how long is the employer obligated to her? Like within that 1 month notice, or like the sick leave doesn't count into the one month notice?
If we go through with the sick leave period, it was stated there that if she's working within 12 months, she had 2 days. So again, if she's still working with her employer and she hasn't finished that 12 days, 48 days sick leave in a year, then she still have the sick leave to be provided, even she had the 1 month notice.
Sorry, let me add. So meaning in summary, during your notification period, like for example, today I gave 1 month notice. Today is the 6th of March, and then I give 1 month notice to my employer, meaning I will leave the job on 6th of April. From 6th of March to 6th of April, this is still, you are still under employment. So the employer has all the obligation to provide you salary, accommodation, and food.
Okay, another question from Lorraine. A question from a friend. Does the fine 100K goes to the government, not to the worker who got fired? The workers can only be compensated if she files a case.
Can you help me with this?
Let me check with the law and then I will come back to you. So the employment ordinance, there are 2 types of claim. One is civil claim, one is the criminal claim. So definitely it will be a civil claim, meaning you can get compensation from the employer and get the money. With if the employer don't pay you wage, this is both civil and criminal case. Not only you can claim back the money for the wages, but also the labor department, the government can sue the employer for criminal offense, and the fine will go to the government as well. So I will check with ordinance on the provision on the sick leave, termination during the sick leave. So most likely it's a civil case, but I will come back to you with the ordinance.
There's another question. It's about annual leave in this present situation. Are we domestic workers still entitled for this kind of holiday? Thank you so much. Annual leave.
For the annual leave is still been, that is already under employment ordinance. So of course, we still have our annual leave, even there's a COVID, that is still being implemented. But of course, with the condition that we have right now, there is a travel ban and there is a flight, yes, lockdown with different area of the country. So for the case of that, there is last year, there is such talks in the labor department, wherein in labor department they said if you cannot go home and you want to be paid by your employer, there is a possibility that you can go out with your days. Example, you go out 10 days and you will be paid 4 days in working, but still you will be paid for your annual leave included in your salary. So your salary is still completed, it's not been deducted, but you can enjoy your annual leave if you want to go out and do it here in Hong Kong. So that is the example that was given before, because there's a lot of domestic workers who cannot go back to their place of origin. So you can still, yes, there is still annual leave is under employment ordinance, so you can enjoy still your annual, and there is still an annual leave for us.
Another question from Rati. The government urged migrant domestic workers to stay at home. So many employers prohibit migrant domestic workers from staying at home. However, there are cases of migrant domestic workers who go out to buy food, but when they return home, the employer terminates the contract and immediately return it to the agent. What should we do to anticipate the same thing?
So the question is that they insist to go out to buy their foods, and then when they come back, they were terminated. So for our rest day off, it is our how to say it. During our rest days, we are given 24 days, 24 hours rest. So we can talk to our employer that this is our right, that we had our 24-hour rest during our day off, and they cannot terminate us for that reason.
Sorry, Rati, can you explain why the worker is being fired and how the employer, what the reason, explain to her? So if the employer assume the worker has got COVID after going out, this is an imputed discrimination, meaning the employer just assume the worker have COVID, and this is a discrimination, and we can file a complaint under the EOC or the Disability Discrimination Ordinance. So because again, the discrimination is about past, present, or future, or imputed to a person. So you just think, imagine the worker has COVID, just assume she has COVID and fire her. This is a violation of Disability Discrimination Ordinance. But if the employer is firing the worker with other reason, then that is another thing, another matter. So like what Jack said, if the employer fire her just because she go out for her weekly day off, so this is not the reason. Yeah, of course the employer has to provide, I mean, if this is an immediate termination, the employer has to compensate her the 1 month notice, salary, etc. But because Hong Kong do not have the fair termination protection. I mean, Hong Kong do not have legal protection to stop employer to fire a worker without a reason, unless you violate discrimination ordinances or fire a pregnant worker, or you fire a worker during her sick leave, then these are illegal. But if this is for other reason, then you just get the compensation from the employment ordinance, like the 1 month notice if she is immediately terminated, etc. So just let us know if this is the case or not the case, and we can study again in details.
If the employer asks the worker to stay home, but she go out for food, but the employer didn't know she go out for food. Come on, and then fire the worker after that.
Translation.
Inaudible, sorry.
And perhaps you can translate a bit of this explanation.
Sorry, the question is inaudible.
But we can't hear you. Is Ratit speaking in Bahasa Indonesia or in Cantonese?
Ratit has muted herself.
But earlier she was speaking.
Yeah, but I didn't get what she was saying.
Does she speak in Cantonese or Bahasa Indonesia?
Yes, mui si tôi xin mention cái đi tên chân xin ngồi chạy công tác gì à cảm nhận kèm trong cái lab là hiện có domestic workers can you pay có chút lab you pay how you phong cả you hay chụp hình có ta phong cả can you you hay okay cảm nhận
can you day off to stay home.
Hay okay, can you ăn sau đấy cái chút thôi mà về xe ăn hay đấy
She went out for food
chỉ
in the
có
afternoon.
you có cái chút thôi mà về xe can you can okay chỉ hậu đấy mà cứ chụp màn phía đấy hồi tí là can you phải tập ngồi mà về xe lo okay mà về xe cảm nhận 跟住咧佢入房之後咧，佢都叫佢出嚟。你而家插嘢啦，跟住跟我去 agent， 跟住到咗 agent 之後咧，原來你個雇主係同佢講，如果炒咗佢啦咁樣，點解啦？跟住佢雇主話，因為我叫你冇放假，但係點解有放假要出去有買一些咁樣，然後如果你返屋企之後，你有positive COVID 咁樣，會點樣啊？都會屋企人㗎嘛，有雇主嗰啲屋企人咁樣。
Okay. Has everybody got the question? So it's like during the rest day, the worker went out to buy food because no food for her. This is already a violation, number one, because employer has to provide food or food allowance. And then the worker went out to buy food. After coming back, she is being fired because the employer explained that the employer already told the worker not to go out, but she went out because there is also a consideration about the COVID infection. So what do the other things about this case? Let's hear what the other think. Do you think this is a violation of the law and the discrimination ordinance?
Yes.
Sorry, Fiz, what's the question?
So the question is, the worker went out for food to buy food, and after coming back, the employer said, I've already told you not to go out, but you go out, so you are fired.
So, but that is during her holiday, if I'm not mistaken.
But that is her day off, is it?
Yes, day off.
Yeah, but that is her day off, so she had the right to go out, especially if you want to buy her food, because that is her rest day. But then her employers told her or asked her not to go out because of the COVID-19. But then because there is no such food that she have, so she insists to go out. Well, for me, if we go through with the rest day, regarding on the rest day, that is your right to go out and you can do whatever you want, especially if you want to buy food. But in that case, she had already said that she had nothing to eat. That's why she go out. And then that is the reason I only see why the first one I see why the employer wants to terminate her, and that is a violation of the employment ordinance. Second is Prati said the employer is afraid that she will be getting positive in COVID-19. So assuming that she will get that, still there is a discrimination under her part, because it is the responsibility of the employer if ever she got positive and she needed to be medicated under her standard contract. So there is two violations that I have seen in that case.
Yeah, so of course, if the worker and the family is under home quarantine under the 599 ordinance, meaning the prevention of the infectious and social distancing, etc., then of course she has to have home quarantine if she has positive. But if this is not the case, just I want to ask, is it prohibited for everybody to go out in Hong Kong now? No, right? So everybody, as long as you don't have the COVID to be quarantined, everybody can go out. So there's no such provision prohibiting anyone to go out. So employer cannot prohibit a worker to go out during her rest day or during her work.
I can add, just like for the call of the Hong Kong government, they keep on calling the employers that There must be an agreement from the worker and the employer if the worker wants to go out. Since it's her day off, so it's her right to go out. But of course, the call is not is strict to what they are saying that we cannot go out. As workers, we cannot go out. So I think there's a violation in there because if you can see, this is my holiday. And the reason why I need to go out is necessity for me to live because I don't have food. I don't have enough. I don't have anything to eat. So I think this is reasonable. Yeah, why I need to go out. Unless that's what we said, that unless the whole family is in home quarantine, of course, that's a different issue. But if there's no positive in the household, why on earth I cannot go out when it's my holiday? Yeah. So I think this is still the right of the domestic workers, and it's an unlawful termination for employer to terminate a worker during the holiday that she just don't want her to go out. Unless you give notice before her holiday, she's already notified 1 week before that she cannot go out on this coming Sunday. That is different, yeah. But on that date, I don't think it's reason for the employer to terminate her. Thank you.
Yes.
Because she's the one who terminate the contract. But the employer was, the worker is fighting that she said, no, because you forced me. And then she did not leave until the employer agreed to pay her for 1 month in lieu. And then finally, the employer called to the agency, and then they go together to the agency, and then she made the employer made her to pay. But to this case, what if the worker is not strong enough to fight such days? Is there any violation for the employer?
Hello? Hello?
Yes, yes.
Yes. I just want to clarify the question that you have raised. Are you trying to say that if the violation of the domestic work, the employer's violation?
Yeah, okay. I will repeat, yeah, clearly. Because the employer forced her to sign a 1 month notice. So 1 month notice, should the worker has to serve it for another 1 month. But because the employer want her to go down right away, so which is she has to serve, supposed to. But the employer wanted her to go down on that day. And the employer said, the worker said, fighting for the 1 month in lieu that she deserved because although she is the one who served the 1 month notice, but
Hmm.
the employer does not want her, the employer do not want to pay the 1 month in lieu, because the employer said is she is the one who terminate the contract, and the worker is fighting for that because she can stay for another month to serve a 1 month notice. But still, the employer does not want to pay the 1 month in lieu, although she wants her to go down right away. But because the worker does not want to agree that she will leave without paying the 1 month in lieu, so the worker was fighting for it until the employer agreed. So my question is, what if the worker is not strong enough like this worker? Is the employer has the violation for that kind of termination?
Okay, I get it. So you said the employer forced her to make a 1 month notice, and the
Yes.
employer already done. We have also to understand that it is
Wait, that's her day off. She asked for just to go down to buy some food, and that's her day off. But the employer does not want her to go down. So instead of, if she go out, then she has to terminate the contract and sign a termination of the contract.
But even how the employer force you, if she really force you to sign a contract, there's already a violation in there. That is a first that is not what we call that. There is a violation on that because she is forcing the domestic worker to write without her consent. But then what had happened here is the domestic worker had write a termination letter too, maybe with her fear. So I think with this case, you have to prove that she was only forced by her employer that she had signed this termination letter. Secondly, you had mentioned that she did not go out because she wanted to get her 1 month of notice. So there's still a consideration there because she had already signed a termination of contract, which her employer wants her to go down, but the employer already gave her the 1 month of notice. Unless in here, just only the 1 month of notice, which was given to the domestic worker and not the other compensation. So if you ask me if there is the violation, yes, of course there's the violation. If if an employer force you to do something that it is not in your own consent, or you are just what is that? Just like blackmailing you for something.
But in court, for example, she will file a case. How will she prove that she was forced to sign?
That's why we always telling domestic workers that if they really want to file a case, there is always an evidence for them to show. Because here in Hong Kong, it's very significant to have your evidence to prove your claims or your complaints. So if she had the evidence that she was forced to write the termination letter, then she can prove that, she can show that if you want to file a case.
Sorry, Mariana, just don't sign anything that is not right. Like if the employer asks you to sign resignation letter, but that is not the case. It is actually the employer asks the worker to be fired, then don't sign a resignation letter, because employers in Hong Kong know very well, if I fire a worker, I have to compensate the workers, like the 1 month notice, etc. So they give you to sign a resignation instead, saying that it's not me to fire you, but you resign. For that, don't sign. Yeah. And then for the evidence, of course, the workers, her own testimony is also one of the evidence that can be accepted in the court in Hong Kong. like the conversation between is also can be accepted. But I mean, just just be assertive, like if this is her right, then this is her right. But again, it is not illegal for employer to fire a worker unless it is a violation of the employment ordinance when the worker is pregnant, under sick leave, or due to the discrimination issues. For other reason, is we don't have the fair termination protection in Hong Kong right now.
Yes, but this one is because it's during her day off. Is it a violation also? Because she wants.
So for that, the employer only need to pay, for example, the 1 month notice, like what the employer need to compensate. So there's no extra compensation on that. Unlike the employer fire worker during her paid sick leave during her pregnancy, then the worker will have extra compensation.
Okay.
You've got me. Yeah.
Yes, yes. Thank you.
Okay, I think the time is running over. Like, let us finish all the questions in the chat box. The first one is from Mary. What if the worker gave 1 month's notice to her employer, but haven't yet submitted to the immigration? Maybe it takes 2 days for the employer to agree on the said termination. But after the worker handed it on that day, the employer made wise decision. She also terminated her worker so that she can have a record on immigration. Is that possible to happen? Or what should the workers do if this scenario happens? And she wants to terminate and the employer terminate before her.
An employer or a domestic worker or employer can terminate contract, but in this case, in this case, for me, if you are, especially if you had a job hopping, this is only my opinion. If you had a job hopping situation, it's better for me that my employer had terminated me and I am no longer be paying my employer. But there's a lot of scenario wherein really employers are the one who's giving go ahead on terminating the contract of their domestic worker, because number one is really, yes, you don't want to have the record, especially if it is a bad reason why a domestic worker had terminated her contract. So, but in this case, I don't know the reason why the domestic worker terminated her contract. So, this is for my opinion.
Is the question also about the notification on immigration? Sorry, I'm not very clear. Can Mary talk about it?
Okay. Hello. I make it clear in my question. I make it clear question. My question is like that. Example. The migrant domestic worker handed the termination 1 month notice in a day, with a reason like example or any reason she has been, if she like to have a break contract. Then after that, the worker doesn't the worker didn't yet submit it to the immigration, because in the immigration said within 7 days you need to submit it, right? So the workers, I think she's still waiting for the agreement of the employer if she will accept the termination or no. And then the employer made a wise decision, like on that day after she handed after she handed the 1 month notice, after she read the reason, then the employer said, I will terminate you today on the spot for giving for this reason as well. Is that possible, that instead of parang in Tagalog, what do you call that in Filipino, parang binaliktad ng amo, instead that the worker will be terminated so that the employer will get a record, but the employer decide to have on the spot to her employer. Is that possible, or what do the worker do? She have what do you call that? She don't have a right for this, or what do you call it? What if this has happened sooner? Because now most of these employer are very very wise now, because they are avoid for have a record also in the immigration, if whatever it is like that.
Kamu udah makan?
I think Jack has answered on the consideration of the job hopping, because now the immigration is punishing the worker if they terminating the contract. So if this is not her consideration, everybody has right to terminate contract. So meaning if the worker gave 1 month notice, you don't need the employer to agree on that. So afterwards, like after 2 days, the employer terminate the worker, then immediately, then the employer has to pay the rest of the days for the compensation of the 1 month. For example, if the worker resign today, 6th of March, and then after 2 days, 8th of March, the employer fire the worker, then from 8th of March to 6th of April, the employer still have to pay for the compensation with a 1 month notice.
Yeah, okay, clear. But I mean, the credit. I mean, the record is for the worker anymore. It's not for the helper. It's not for the employer, because employer, maybe the priority for termination is the worker, is the employer, because the employer on the spot terminate her worker because she giving a 1 month notice. What do you call that? Instead of a 1 month notice, so that the employer will not have a record with this, because scared of that cold record in immigration, if whatever the worker put a reason for that, like that. So I mean, because I didn't get the clear point of this question. Maybe I mean the what they point out. I mean the most. I mean the what do you call it? Because like us, it is unfair, because I'm wanted to break my contract, but my employer suddenly on the spot me. So I lost. It's my lost, because instead that I'm the one giving the record to the employer, but she's the one making a record because of this 1 month notice that she is afraid to have a record in the immigration. Hope you got it. Thank you.
On the employment ordinance, the employer still have to pay for the 1 month notice.
Fish, if I may add on the concern of Mary.
Okay.
I think it's, if you only want the employer to have a record with the immigration, I think the best thing is you make some recordings, and then you can before you have the decision to terminate your contract. I think what happening on your daily activities at home, or anything that is not favorable with you, or something like verbal abuses, or anything that makes you been discriminated by them, it's for you to record and give evidence to the immigration before you have to take some action to terminate your contract, so that the employee can have some records with immigration already. That's one thing. Because some employers are really keen on doing this, because they think that this cannot be a record for them to terminate workers. But we keep on saying either that we try to advocate also to our consulates, because they are the one finalizing the contract. I think that is one thing, to blacklist all these employers for doing this kind of violations and strategy to really terminate their workers, and they don't want to have some records on it. So what we do is, I think, is to advise anyone to record it every day, so that we can submit to the immigration, we can submit to the consulate, and we can submit to the labor department, so that there will be a record for these employers who's doing like this kind of of attitude.
Okay, thank you. I got it already. Okay, thank you.
Thank you. Hope I answer your question.
Yeah.
Okay, let's quickly wrap up all the questions. There's a very important one, I think. She asked my employer, ma'am, my employer said she doesn't have responsibility about my case because I got lump on my breast and the clinic said it's all cancerous. My employer availed the cheapest insurance. That's why my situation is not covered to the insurance that she availed. So what she can do in this case?
Still, we go again with the standard contract and the employment ordinance that employers responsibility to provide the medication of a domestic worker about as long as she is working still with her. And secondly, it is a discrimination to terminate your worker while in the medication or she is having this kind of illnesses and she will having this kind of treatment. So that the employer cannot terminate her worker during her treatment, or even she had this kind of, especially she had this kind of illnesses. If she got this insurance for her, then that is her problem. But on her standard contract, she have to stand that, she had signed that, and she have to understand the employment ordinance that it is her responsibility. The domestic worker is the employer's responsibility while working with her environment or inside her home or house. I hope I answered the question. Any additional?
Okay, there's another question from us, but I think we already answered that question earlier. And there's leftover from like last section about the quarantine for having COVID case. I want to ask, is Ansel still here to answer questions? And Ansel, are you still there?
Hi, yes.
Yes.
So I see the question is that the domestic worker is living with a grandmother who's infected. So she would be a close contact, and normally the government would have to arrange her to stay at home, but it seems like I'm not sure if the grandmother has reported her illness to the government or not. So I would suggest that she check whether the grandmother has given the report either by PCR or the rapid antigen test by calling the hotline to the government. And the government should arrange the stay home safe scheme, which is the one where she waits at home 14 days. So, but I'm not sure, of course, if the government might be struggling with caseloads. So if we're talking about just her own quarantine, it should be 14 days. Yeah, and she should be testing on the regularly to see if she's positive or negative. But at the very least, the baseline again is to I guess she can't isolate that well because she has to take care of the grandmother. So she should try to at least disinfect and perform hygiene as I mentioned in the presentation.
I will repeat the worker's question. It's like, I have a question about my issue. I live with a grandma and she was infected by COVID when 6 days of her first vaccination dose, and I take care of her at home when she got sick. I'm not vaccinated. I have test every other day, the rapid test, but I'm lucky I'm negative to those tests. My question is, I need to isolate with a grandmother and how many days? Okay, thank you for all the participants to answer all the questions. The meeting is really prolonged for almost an hour, and all thanks for your patience.
Sorry, and then I want to reply on the question of the sickness.
Yeah. Okay.
Okay, so earlier there was a question, the fine of 100,000 will go to the worker or what, who? So I'm sharing this website from the Labor Department on the labor legislation. So it is said that the employer has to compensate this number 1, 2, 3 payment in lieu of notice, the wages as compensation, sick leave, sickness allowance. And so these are civil, meaning the worker can claim. And in addition to that, the employer will be liable to prosecution by the Labor Department. And if convicted, the fine of 100,000, meaning this is criminal. And of course, this fine will go to the government. So the worker can have a civil claim. Besides that, the government can sue the employer for criminal claim.
There's another question in regards about the issue of cancer patient worker. Kindly give groups of NGOs to go on case they got terminated for the employee. Is there any recommendation of NGOs or hotlines that can help this cancer patient? Dan, can you speak for conclusion, for a little bit conclusion for this meeting?
好，大家好。
係
首先咧，我哋咧係就嚟
Good day, everyone.
3月8號，我哋希望咧，我
The 8th
個
of
身體
March
健康。
is the International Women's Day. I hope
好
you
多
are good
謝
health.
講者，好多謝
Thank the speakers
問答問題。
for the
呢個咧
Q&A
俾
section.
我哋嗰個真係知道而家疫情香港咁嚴重咧，係
Let us
個
know
個我
the
哋
situation
係知道感染
of the
咗
COVID
點樣
and
搞
the
法。
syndromes.
呢個而家咧真係好練，希望咧我哋咧一齊打贏呢個場仗㗎。好多謝大家，唔該晒，
Thank you everyone. Thank you everyone. Thank you
我
very much.
哋咧希望參加呢個論壇多啲，因為咧呢個都係我哋
I
做
hope
嗰個
this
情
kind
況。
of forum will be organized more.
好，多謝晒。
Thank you very much.
Thank you, FADWU. Thank you, Fish. Thank you, everyone.
Thanks. Happy International Women's Day.
Can we have one chant?
Yes, one chant. And do we need photo, group photo?
Yeah, please open the camera, take group
Turn
photo.
on the camera. We will have group photo and have a chant.
Everybody turn.
Women's workers.
Yes.
One, three, konka.
Su.
Okay, 1,
Okay.
2, 3. What?
Five.
Laban.
Kai and Gong.
Are we done for taking pictures?
Employer said it's not